Welcome to Behind the Headlines. I'm Edward Adams. In the world of law firm mergers, Canada is suddenly the flavor of the month. Norton Rose, which has 5 Canadian offices, recently announced it is pairing up with the United States' Fulbright and Jaworski. International law firm S.N.R. Denton merged with France-based Salons and Canada's Fraser Milner. And Canada's Fasken Martineau acquired Johannesburg, South Africa's Bell Doer. Here to help us figure out why Canadian firms are sexy all of a sudden, we have Jordan Furlong, a lawyer and law firm consultant at Edge International and STEM Legal Web Enterprises. He joins us via Skype from the great city of Ottawa. Jordan, welcome to the program.
Thank you very much, Ed.
You know, Jordan, these are very different kinds of mergers. Can you outline for us what the strategies appear to be behind them?
Well, these definitely are very different kinds of mergers, especially from the Canadian perspective. If you go back, Baker McKenzie was the first international firm to come to Canada, but that was back in the 1960s. Between that time and 2010, there was no international firm activity in Canada, and now today we have 4. And 2 of these firms are simply massive, Norton Rose and S.N.R. Denton. To put that in perspective in the local context, the largest Canada-based law firm in terms of number of lawyers is about 800. Now, following the Fulbright and Jaworski merger, Norton Rose clocks in somewhere around 3,800. So you can see what kind of impact that's having on a market that's really used to measuring large firm size in the hundreds, not in the thousands. In terms of the strategies that are driving this, certainly to an extent, there's a desire for differentiation. I think many firms, they see this as a very tightly packed, highly competitive big law market here in Canada, and they look for ways to set themselves apart from the market. And having an international reach, a global platform, and having that kind of international branding, I think, is very attractive to firms in that regard. But I would say that the strongest driving factor is the desire for that global platform. Now, in fairness, any number of firms in any number of countries could say that. What makes Canada a little bit different, though, is that the pressures here a little bit unique. This is not really a country with a huge corporate base. I think something like only 10 or 11 of the Fortune 500 companies are Canadian. So this is a country where the economy really depends heavily on trade. Now, traditionally, and still to this day, Canada is the United States' #1 trade partner. And there's been a huge amount of north-south traffic. But we're just right now on the verge of completing a free trade deal with the European Union. And just a few days ago, a Chinese state-owned company bought out one of Canada's energy companies in the oil patch. So in that context, in those circumstances, the best legal work really is global now. And in order for you to be able to be competitive and to really make your mark, then you have to be in some kind of position to have an international platform. Canadian firms have not traditionally, for the most part, had much success in getting themselves positioned and creating greenfield operations overseas. So for many of them, they see the international merger platform as the best way to go.
There are a lot of opportunities, clearly, with these mergers, but also there are bound to be risks, I would think. I mean, you had mentioned that Canadian firms have historically shied away from linking up with U.S. counterparts. Is that a risk, at least in the case of the Norton Rose Fulbright tie-up? Is there some danger that some of the operations may change as a result of that?
Well, the risks are very real, and you're quite right. The reason that there have been so few U.S.-Canada tie-ups in the past has largely been that Canadian law firms receive so much referral work from the multitude of American firms that really have so many opportunities to deliver work, and there's a fairly small community of firms in Canada that can receive it. So that has always been the kind of the red line that firms have been very reluctant to cross, because they fear if we commit, if you will, if we make that marriage to one particular firm, then all these other pipelines are going to shut down. We will have to just rely on this one particular firm to either to deliver the work to us or to help us to build new markets, both in Canada and elsewhere. Now, the Norton Rose Fulbright Jaworski illustration is actually a very apt one, because I think that's a really good example of a firm of two firms that have a lot of resonance and a lot of integration. You look at Fulbright and Jaworski, which is obviously a very strong firm in terms of energy. Norton Rose's Calgary office, the former McLeod Dixon, extremely strong as well in the energy field. And McLeod Dixon was one of the firms that really had some success in creating offices overseas. Before the merger, they were well established in places like Venezuela and Kazakhstan and places like that. So the primary risk absolutely is the loss of referrals, the danger, I suppose, that comes with overcommitting. But I think Norton Rose also demonstrates that you can mitigate those risks if you choose your partners well, if you align yourself in terms of industry, in terms of practice area, and really in terms of culture. I mean, we throw that term around a fair bit, but it actually does mean something when it comes to mergers and alliances and tie-ups of all kinds.
Clearly, these firms are going to get larger and they're going to have more offices. They're going to be able to serve more clients, perhaps larger clients. But does increased profitability necessarily flow from that?
Well, that's a key question and a key consideration for firms that are going to consider the merger route. I mean, the key element of most of these mergers that are taking place right now, and the Norton Rose and Denton's examples are particularly apt, is that they're Swiss vereins. And of course, one of the underlying fundamentals of a Swiss verein is that there is no sharing of profit pools. They are all very much kept independent.
Just so I'm clear on what that exactly means. That means that the profits earned by Fulbright stay with Fulbright, and the profits earned by Norton Rose stay with Norton Rose. Is that the way it works?
Yeah, for the most part, that's true. And there's no melding of the profit pools in the sense that traditionally, I guess, in a fully merged integrated firm of any kind, the rising tide does lift all boats. Everybody is kind of patched in completely to the pool. The verein is not like that. The verein essentially says we're not going to share those profit pools. It's part of the overall inclination under a verein system that the, if you will, component parts of the firm retain a fair bit of autonomy in terms of their practices and their finances and their I suppose their, again, culture, not to overstate the matter too much. But I think
if they're going to maintain that much separateness, what's the beauty of merging in the first place? I mean, what do they get out of a merger that they wouldn't get out of the status quo?
Well, exactly. I think the two main drivers that would appeal to firms in those circumstances, the first, as I say, is that access to not just the larger international brand, which is important. It carries some significance and it carries a lot of weight, again, especially if you're serving a client base that does have global ambitions. But many times these larger international firms are going to have a tremendous depth of knowledge in terms of KM. They're going to have bench strength, I guess you could say, in terms of marketing and in terms of know-how, and in terms of being able to really extend your reach in terms of business development, in terms of making yourself known, building up your profile and building up your prestige. The other aspect of it, I guess, is the element of cross-selling, which is the oldest, if you will, headache in the law firm management book. Because again, when you are drawn to a global platform, part of the reason for that is that yes, you are hoping that your new partners in other countries are going to help you drive new income, drive new business your way, and that you in turn would be able to do the same thing. Now, obviously, cross-selling is a challenge for law firms of any kind, whether they are based in one city, whether they measure their numbers in either hundreds or thousands. It does become more of a challenge with a more far-flung entity like an international merged firm, and it becomes another challenge again with the Swiss verein. So the challenge for the participating firms, and this is not just the Canadian firms that would join, this is for any of the firms involved in a verein operation, is to really make that commitment to building and integrating especially the practice and industry groups together, to build the foundation for the relationships and for the trust. That's what cross-selling really relies on. So it is absolutely a huge upside opportunity that comes out of these kinds of mergers, but it's something that you absolutely also need to work on.
So last question, Jordan. Which Canadian firms do you think might be next to consummate a cross-border merger of the sort we've seen so far?
Well, I can tell you there's no shortage of speculation, as you might imagine, within Canada. I've certainly heard any number of mid-sized firms and large national firms mentioned. And you hear global firms mentioned as well, occasionally Magic Circle firms and U.S. firms, as having expressed an interest or going so far as to being in full-scale talks.
Well, which of the major Canadian firms have you been hearing may be in talks at this point?
I really wouldn't want to identify, and the reason is that it really is just rumor and speculation at this stage, and adding to that, I think, is problematic. What I do know is that there's a couple of factors that are going to be, if you will, sine qua nons for any international firm coming to Canada and considering a merger partner. Obviously, having a very strong presence in Calgary, in Edmonton, in the oil patch, with the extensive, immense potential of the oil sands, that's a very key consideration. Obviously, again, if you are interested in financial services, Toronto is a key area. And Vancouver gets overlooked sometimes, but it shouldn't. Vancouver is the gateway to Asia Pacific, to China and Hong Kong and Australia, and all these emerging, developing economies in that part of the world. So as much as anything else, as a potential, as a law firm looking for potential merger partner in Canada, I think at least as much you're looking for locations, you're looking for industries. I will say this, it would be very surprising to me and to a lot of other observers if any of the firms that are considered, if you will, the top firms, the elite, just off the top of my head, names like Stikeman Elliott, Blake Castles and Graydon, Osler Hoskin, McCarthy Tetro, firms like that. It would be very surprising to me if they wound up in a merger with an international law firm. But I'll also say this, if they do, if one of those firms or firms of that caliber end up going into an international firm, whether it's an alliance or a full-scale merger or a variety or whatever, then all bets are off, because that is going to turn the market here upside down, and people are going to have to deal with an entirely new reality in terms of what the big law marketplace looks like.
Well, it's certainly going to be interesting to watch. Jordan, thank you for sharing your insights with us today. That's Behind the Headlines for this week. Thanks for watching.